Consent to act. Okay, in the duties owed, I kind of went into the potential conflicts of interest that are full or better explained in the consent to act. So I think you should pretty much have a good idea about the conflict of interest in dealing with dual agency. So we'll just go ahead and read this form. Consent to act. This form does not constitute a contract for services nor an agreement to pay compensation. Okay, description of transaction. The real estate transaction is the sale and purchase or lease of property address. And there you would write in the property address. In Nevada, a real estate licensee may act for more than one party in a real estate transaction. However, before the licensee does so, he or she must obtain the written consent of each party. And that is done on the duties owed form and on this form. This form is that consent. Before you consent to having a licensee represent both yourself and the other party, you should read this form and understand it. Licensee. The licensee in this real estate transaction is blank, and there you would put in the legal name of the licensee, whose license number, once again, remember, it's the Nevada State real estate license number. Sometimes agents get their public ID and their license number mixed up. So you want to always make sure that you're paying attention. Are they asking for my license number or for my public ID number, which is the number that comes from the Association of Realtors? And who is affiliated with? And there you would put in the brokerage name, and then the seller or landlord name you would print, and then the buyer and tenant, and you print the name. Conflict of interest. A licensee in a real estate transaction may legally act for two or more parties who have interests adverse to each other. In acting for these parties, the licensee has a conflict of interest. Disclosure of confidential information. Licensee will not disclose any confidential information for 1 year after the revocation or termination of any brokerage agreement entered into with a party to this transaction. So that's a buyer, seller, both. It can also be a landlord and tenant. Unless licensee is required to do so by the court of a competent jurisdiction or is given written permission to do so by the party. Confidential information includes, but is not limited to, the client's motivation to purchase, trade, or sell, which, if is disclosed, could harm one party's bargaining position or benefit the other. So, when you're selling somebody's house, well, it's been my personal experience anyway. I can't speak for every single agent out there, or I can't tell you what's going to happen with you, but it's been my personal experience that sometimes you get rather close to the client, the buyer or the seller. They start confiding things with you. They tell you if they're moving. They tell you if they've already bought another house and they have multiple home payments and they're stressed out about it. And you can also find out too if they're wealthy, that sort of thing. This information, you want to be careful that you don't disclose it to other parties. Remember, you're representing them, and you don't want to disclose any material facts that could potentially jeopardize their position in the negotiation. So, when they tell you something in confidence, keep it to yourself. And it's better. Your clients will appreciate it. You will get repeat business if they know they can trust you, and they know that you did a good job for them. So it's in your benefit too. Okay, duties of licensee. Licensee shall provide you with the duties owed by a Nevada real estate licensee, which is what we just trained in the previous video. Disclosure form, which lists the duties of a licensee owes to all parties of a real estate transaction or those owed to the licensee's client. When representing both parties, the licensee owes the same duties to both buyer and seller. Licensee shall disclose to both seller and buyer all known defects in the property. Okay, remember, property, not person. Any matter which must be disclosed by law, and any information the licensee believes may be material or might affect the seller or landlord's tenant's decision with respect to this transaction. So If you know something material to the property, you want to disclose that. Anything that's about the people, you don't want to disclose that. Okay, remember, you can check back with your about the fair housing. That tells you exactly what you can and cannot disclose as far as the people, and try to be confident for these people. Okay, no requirement to consent. You are not required to consent to this licensee acting on your behalf. You may reject this consent and obtain your own agent. You may represent yourself. And there's an exception to that rule, but I'll get into that a little bit later. For now, let's just say that they have the right to represent themselves. They have the right to reject you as an agent, and they can request the licensee's broker assign you your own licensee. So they can even ask the broker to just assign them another licensee within the brokerage. This is very rare. I've been selling real estate part-time for about 5 years and full-time for 7 years. I've never had this situation happen, but just know that it can. And I really have never dealt too much with investors. Most of my clients have always been first-time buyers or people that are buying a house to live in. So I never really had this happen to me, but just be aware that it can. And when it does happen to you, respect that. Respect their wishes. And do the best that you can for them. Don't be so worried about trying to get both sides of the transaction. A happy client will send you repeat business and they will buy from you again. So think long term. Okay, continuing. By my signature below, I understand and consent. I am giving my consent to have the above identified licensee act for both the seller and party and me by signing below. I acknowledge that I understand the ramifications of this consent and that I acknowledge that I'm giving this consent without coercion. Okay, and then in the bottom they would sign the date, the time, and once again, remember, you always let them sign and date their own documents. And once again, remember that you want to give them this document to sign before you go out and start showing property or showing potential buyers to your client's home if you're representing the seller. So this goes hand in hand with the duties owed. You want to give both of these documents to them right away.